Right, let's start off with our first big story. The governor of Abia State, Okezie Ikpeazu, has described his victory at the appeals court as a landmark judgment.
He said that the judgment has proved that the judiciary will continue to play its vital role to sustenance of democracy. Ikpeazu's victory is also a strong indication that the judiciary will always be the last resort for aggrieved persons.
The Abia State governorship seat has been well contested via the ballot box as well as the judiciary. After battling through at the election tribunals and claiming victory at the Supreme Court, Governor Okezie Ikpeazu has had to grapple lately with court cases instituted by Uche Oga and Friday Nwosu aimed at unseating him. The case, which borders on alleged tax clearance falsification against Ikpeazu, was eventually decided on Thursday after Governor Ikpeazu approached the appellate court challenging the verdict of Justice Okon Abang of the Federal High Court, Abuja, which sacked him from office.
This to us is a victory for the common people of Abia State that voted massively for us in 2015 general elections. We will be reinvigorated to continue our service to Ndabia without let. We must thank God Almighty for His mercy and grace upon us, and also say that the gains this country has achieved in terms of our democratic experience is too precious for us to toy with. We can recover from our economic problems, but we may never recover if we draw back on our gains in terms of democracy.
The judgment naturally threw Okezie's camp into raptures. Both men, women, and youths immediately trooped into the government house in Umuahia, singing, dancing, and praising God.
God is watching us. Ever since we've been praying and asking God, are you not there? Are you not seeing what is happening? But today, God has shown us that He's a merciful God.
That we are overwhelmed and we believe in the judiciary. We know that things will come to normal as far as the judiciary is concerned in this country. And we are saying thank you to the judiciary of Nigeria.
Thank you, judiciary.
Members of the PDP Board of Trustees, led by Senator Wahid Jibrin, who are in the state for the late Ojomadekwu's upcoming burial, also joined in congratulating Governor Ikpeazu for his judicial breakthrough.
We are the first to visit you after your success. That is long expected, and we never had any fear in our mind that you will lose this case. Never.
As at the time of filing this report, all efforts to reach Uche Oga's camp had not been successful. Nnamdi Ofonye, TVC News, Umuahia.
All right, joining us now is the legal consultant to the Abia State Governor, Obinna Nkume. He's also an Aba-based lawyer. Obinna, it's good to have you join us right now.
Thank you.
You're welcome.
Good to meet you.
Yeah.
Good morning.
Now, let us have a basic understanding of this issue. When it comes to clearing a candidate for an elected position, whether governor or whatever, at the level of the screening, we feel that at the level, if there are discrepancies in either the person's, whatever it is, the credentials the person is trying to present to say, okay, these are things that qualify me for this office, as the case may be, we feel that it is supposed to be at the level of the screening that he's rendered either disqualified or qualified for the post of whatever he's contesting for. At this time when the contesting, everything has been done and conducted, election done and conducted and won, as the case may be, and lost. And then we hear tax clearance issues that were supposed to have been taken care of at the level of the screening. What does the judiciary, or what does the law say in that regard?
Now, first of all, I'd like to clear one point.
Okay.
You talked about qualification. When you talk about screening has to be geared towards qualification for a particular post. But in this instance, we are talking about the position of the governor. If you go to the 1990, the Constitution of Nigeria, you go to section 177, you will see the qualifications streamlined there. And of course, there are not too many. The person has to be a member of a political party. The political party has to sponsor him. He shouldn't be no less than 35 years. And of course, have no less than a school certificate. That is the only basic qualification for anybody that is going for the post of a governor. In that situation, if you are going for screening, this is what the political party will look at. But in this instance, I must add that the party itself may also have its own criteria in addition to this. And this instance, if you go and look at the PDP constitution, you will find out that the only additional qualification they may add there is that the person should show only evidence of tax payment, which of course Governor Ikpeazu presented. He presented his tax receipts, presented his tax clearance duly issued by the authorized body, Board of Internal Revenue. So with that evidence, all qualifications were complied with. But here, a scenario tried to play out by a gold digger, aspirant who lost. Instead of yielding to that losing, started shopping for one or two things with which to try his luck. It's not a game of luck. It is a game of law. The law must take its course. And that is why you see where we are today, that the Court of Appeal has been able to state the law as it is. Because the basic criteria upon which he tried to do that was they went and read it into the PDP constitution, a clause that was not there, that the person should show evidence of payment of tax as at when due. As at when due. So in that situation, they now read what.
So that was what the judgment said. We're talking about adding a clause to PDP or speaking for the PDP, instead of allowing the party to speak for itself.
That is correct. And that was basically why the Court of Appeal said that that was even a violence and infraction of the constitution of the PDP that sponsored, because that clause was not there. It's only the Justice Abang Okon who knows where he imported that clause, possibly to achieve whatever desired end he wanted to get to.
If we look at the judgment piece by piece, perhaps, where the late Justice talked about Justice Okon-Nabanks, that he stood the law on its head, adopted a hostile proceeding. What is that really talking about?
Well, you know, the law has its own procedure. And in fact, there is even no legal justification upon which that particular judgment of Abang can stand on. Too many things. He changed the law upside down. But I can give you one or two instances. In the first instance, Dr. Oga rushed to court and said Dr. Ikpeazu, the governor, did not pay his tax as at when due, and that the tax document he presented for the screening was not correct, was false document. This was the basis upon which he went to court. Now, at the level of the judgment, because he was not able to prove that those documents that were false or there was false information and affidavit, the judge on his own imported the fact that Ikpeazu should be the person to prove that the documents he brought was not falsified, and that there was no false information.
The tax boss in Abia was not allowed to testify.
That is correct. So that means it's an infraction of the law, or turning the law upside down, because in law, he who asserts must prove. So if you leave the person who asserted and not to discharge the burden of proof and transfer it to the person who ordinarily should be discharged without any evidence, that is one of the instances of turning the law upside down.
Okay, now if we go back to the primary level of this whole thing, Dr. Oga and the governor Ikpeazu are members of the same political party. At that level, we were thinking at the screening level where it is mandated that they are supposed to, as part of the criteria, bring some of this documents, provide these documents, tax clearances and all of that. At that level, we were thinking the party should have even handled that long before the issue of the court comes in.
Yes, obviously the party did it. Okay. There was no problem with the screening. There was no problem with any document. As a matter of fact, the PDP gave Dr. Ikpeazu a clean bill of lading. There was nothing. And it was on the basis upon which all the aspirants went to the field. And by the end of the exercise, Dr. Ikpeazu won overwhelmingly. Dr. Oga came second, a distant second. So at that level, the party had finished, submitted the name of Dr. Ikpeazu to the electoral body. And thereafter, his nomination processes came in. As a matter of fact, there was something that really played in there, in fact, because that also brought us to part of the judgment which some people probably will not appreciate. Because Dr. Oga was overzealous together with his friend, I call him his friend because I tried on a gold digging, Friday Wosu. They quickly rushed to court complaining about false information in the tax document when Dr. Ikpeazu's documents had not been submitted to INEC. At that level, no cause of action should have accrued under the Electoral Act. Because under the Electoral Act, cause of action will accrue under Section 31. You can read it sub 1 to 5. Only when you now submit your documents, and if anybody under 31.5 now feels there is any false information, you can go to court. So even at the level they rushed to court, no cause of action no document had gotten to INEC. So there was even no basis to go to court. And that was why the Court of Appeal said there was no reasonable cause of action, even in the matter. So there was no basis even to move into any dispute or any resolution of any dispute at that level by the trial court.
Okay.
Yeah, you said that the PDP had given Governor Ikpeazu a clean bill of health, as the case may be. Dr. Oga is a member, a card-carrying member of the PDP. At the time he was going to court, what was the position of the political party at that time?
Obviously, there are internal mechanisms
for
resolving all these disputes. If anybody is not satisfied or is aggrieved by that, the internal mechanisms are there. You also have the electoral committee, the appeal panel. You take your complaint to that place, just like the court. Justice Abang has done his due, and the Court of Appeal said, no, you are not right. You didn't do it right. So if he wasn't satisfied with the primary election at that level, he could have gone. And if you go there and you lose, that matter ought to rest there within the party. There is no other action anybody can take that can be justiciable, because it will now border on the internal affairs of the political party, which nobody can go to court and assert. That is why, even though it bordered on the internal affairs of the party, he tried to elevate it to the level of bringing it within the Electoral Act so that he can have something to complain.
Otherwise, PDP will have been joined in the as a plaintiff in that case. Okay, okay, but let's look at the relying on Section 131, subsection 1 and 2 of the Electoral Act, which Justice Abang actually alluded to in the case of Amechi, and where issuance of certificates and that, according to what we have, the judgment now says it's not really applicable in this matter. That even in the case of Amechi, then instead of giving him a new certificate, all what happened was just to swear him in as the governor, not issue a new certificate to him as a governor. Can you expatiate on that?
Yes, primarily, in fact, I had done a work on that when I did a rebuttal about a publication by my learned friend Kaimo. I did elaborate exhaust that point even before the judgment came. And what we did was on all fours with the judgment, because there was no basis to order a certificate of return to be issued to Dr. Oga, who did not participate in the whole process from the beginning to the end, in line with the Electoral Act when you have regard to Section 141 of the Electoral Act. Then when you talk about 131, you find out, you can fall back to Section 57. You see the criteria upon which you can give issue certificate of return. It is the electoral body that will issue that after the elections to whoever emerged, which they did to Dr. Ikpeazu. Now, if you go to court, if you look at that judgment, you find out, and that is why there was all that imbroglio. The court did not set aside the certificate of return that had been issued to Dr. Ibaza. So it's a new scenario from when you finish from the field, nobody has been issued. You can go to court and order. Where that kind of order can come in, if you had won and the electoral body, nobody had been issued, the electoral body, for whatever reason, refused it, you can go to court and order them to issue you. But when it has been issued already, and now somebody has it, you cannot order another certificate of return to be issued to somebody who didn't even participate. And that wasn't what happened even in a Mechi case, which the court relied on.
Yes.
That is also another turning the law upside down. At that level, Mechi, the point would have been to order that the person be sworn in. And that order, if you go to Section 57 of the Electoral Act, ought to have been made by the court of final instance, the Supreme Court.
The Supreme Court.
In that situation, that order becomes the tool with which that person will be sworn in. You don't order to issue another fresh or another subsistent certificate of return when there was, or when there is still one existing.
Or at least when the other one hasn't been withdrawn.
When it hasn't even been withdrawn. And that is it. So if you look at it, you will see that some of these flaws or some of these gaps that created the whole impasse at Abia State, because the man armed with this hurriedly issued certificate was shopping for where to get a judge, a judicial officer that was swearing him, even when there was even no order. If you go through that judgment, you see that lacuna there. There was no order.
You're talking about originating summons and
yes, the order on the originating summons. Abba did not make a consequential order for him to be sworn in. You don't issue certificate and leave him and you start taking it around and start looking, because that is what created that problem. So on the whole, you will still find out that I'm sure he got stuck. He got stuck and couldn't move further, but he just had to deliver on the whatever he wanted to achieve. Let me leave it at that level.
All right. Now, on the other hand, INEC, that is the umpire that's supposed to coordinate all of these. We expect, because we sit down and watch how it carries out or implements or executes its legal process of that have legal implications here and there. Now, we expect INEC to have known on how to express all of these things. But however, we are here where we are right now. So what happens to the second certificate of return that was issued to Dr. Oga?
Well, in the first place, is a nullity. By the judgment of the Court of Appeal, it has become a nullity. And when a document is null and void, it is of no effect. So whether it is cancelled or withdrawn, or Dr. Oga pictures it and go and keep it in his bedroom for whatever use it, it's of no consequence. In any case, rightly, if the electoral body wanted to do the right thing or is still desirous of retracing their steps, particularly when the way and manner upon which they did this job that looks like a hitman job, if they want to redeem part of it, the proper thing they should do is to call and withdraw for withdrawal of that certificate, not because it's of any value, but it has no basis to remain in it. They call. It's akin to when a student gets a forged certificate or gets a certificate which he is not entitled to. If the university body at any point in time finds out that you don't merit having this certificate, you withdraw it, right, and withdraw it. That is what we expect INEC should do, to still try to see how to build up its battered image with respect to this particular occasion or situation. But whether it is withdrawn or not, by the decision of the Court of Appeal nullifying the decision of Abia.
But INEC could not have gone against the court ruling as at the time it came from Justice Abang.
Yes, that is where you've taken us to where they really put themselves or shot themselves on the leg, I must tell you. You see, basically, the electoral body didn't start this business today. They ought to have a well-instituted legal body inside that should give them legal opinion. this is not the first time a pre-election matter is coming up. At that level, there was a decision of the Court of First Instance. And by their own admission, they have admitted there was an appeal, a notice of appeal properly filed, which they say had been served on them. The only area they tried to, regulate was that a motion for stay had not been served, which of course we found out to be false because they owned it up, Now what they ought to have known was that you do not have to text them because they're a party to that proceeding. They are no more a neutral umpire. They were a party to that suit. Therefore, the law expects that a party to the suit will not take any step that will nullify the constitutional right of exercise of appeal by any party who is agreed by judge. They ought not to have issued that certificate until the Court of Appeal is able to look at that matter, and then of course the apex court. And you can draw this, it's very simple.
But will you blame INEC if Justice Okonabang also got that application that this matter is before the appeal court and went ahead and ruled anyway?
Yes, we will, because at that level, you can see that that's another flaw, that very ridiculous, what Justice Abang did in that situation. Because, it's an elementary principle of law at that level, that once you get the matter filed, notice of appeal, and you transmit the record of appeals, which was hurriedly transmitted under the circumstance, and notice was put on it. Yet, he continued, he went ahead to interpret the Court of Appeal rule to try to see what he can do. At that level, he was supposed to answer. He was supposed. So, if you look at the case of Amechi, you look at the case of even P2B, you find that P2B it should even have been a worse scenario. Because this was the governor who was there, and by whatever, you removed him, he now went pre-election. Even when he had a judgment of the Court of Appeal, he had been in the government household, he didn't hurriedly want to move in. He waited until the apex court gave the final nod before he was restored back. The same happened in the Amechi case. So the electoral body ought to have known, unless by the state of the law, you find out that that person did not invoke the constitutional right of appeal. If you wait, you can now know what steps to take.
All right, Obinna Nkume, thank you very much for coming on TVC Breakfast. There are other things we would have really discussed in here, but we don't have all the time now for that, but certainly other times will come. Thank you.
Thank you very much.
Thank you for coming.
Thank you.
Now, we're going out on TVC Entertainment, but viewers there can continue with TVC Breakfast on TVC Concert Channel 190, DSTV 418.
Go TV 45, ACTV, it is still 510, so log on. Let's continue the discussion there.